Mr Chairman.
Honourable Phil Goff.
Mr Chairman, Part 4 amendments to the Legal Services Act 2011, and the bill makes it very clear what the effect of this is. The effects of the new subsections 3A and 3B is to limit the availability of legal aid in proceedings under the Care of Children Act 2004 in the Family Court. This is part of the guts of the bill that says we are going to stop lower income people who can't afford to be represented from getting justice in court. That's what this bill means. Let me read, it's really interesting reading what the regulatory impact statement says about this bill. Actually, my favourite sentence is this. You've got to listen to this, Minister. You'll really appreciate it. This option only affects those parties who, because of their low income, are eligible for legal aid. Yes, isn't that obvious, Minister? This part of the bill only affects those on low incomes who can't afford legal aid. Minister on a $250,000, $250,000, if she needs help, she won't need to worry about it. People who are really well off will do just fine. But the families that are struggling to have representation will be denied representation by this bill and by other pieces of legislation that you, Minister, have passed. You know, it says here that the real justification of this is because family legal aid went up between 2006 and 7 and 2010-11 by 93%. You know why it went up, Minister? Because for the first time in 20 years, the rates of payment for legal aid were adjusted to bring them into line with the rate of inflation over the intervening period. Legal aid is about ensuring justice to people to be represented, and this minister says no. And why does she say no? It says it in the regulatory impact statement. The fiscal constraints faced by the government mean there is not currently sufficient funding. Well, Minister, there was sufficient funding to pay the costs of Rio Tinto, $30 million. That wasn't a problem. Corporate welfare, no problem at all. Warner Brothers, come in, yeah, add another $16 million to the $40 or $50 million you're already getting in subsidies. No problem at all. Corporate welfare is okay, but allowing people to have the funds to have justice for themselves and their kids are the first target. And you know why they're a target, Minister? Because they're vulnerable, because they can't fight back, because they can't articulate their case, they can't stand up for themselves. But Rio Tinto, yeah, well, they say, well, look, OK, we'll keep you going just until you can sell Meridian, and then we'll pull out anyway and the jobs will be gone. But in the meantime, yes, we'll take $30 million of the taxpayers' funds. And that's not all, Minister, is it? You don't have the money, you say, in this document to fund legal aid for kids. You don't have the money. But you did have the money to give yourself a fat tax cut, and the Prime Minister probably walked away with $150,000 a year in tax cuts. No problem with the money there. No, the money's available. But get some struggling mum with her kids trying to get justice in the family court. Oh no, that's not a priority. That, I think, is absolutely appalling. It stinks. It stinks that we cannot provide justice for our kids, but we can provide tax cuts for the wealthiest people in New Zealand. Well, maybe they didn't get quite that much because most of them aren't paying their share of taxes anyway. So it is about priorities. Politics is the language of priorities. And what you're telling the House, Minister, is you don't have money to give legal aid to those who need it, but you do have money to look after the fat cats. It's as simple as that. And look, your own regulatory impact statement makes the comments. OK, they say the opposing party may have a lawyer, as opposed to the party that can't afford a lawyer. This could lead to the represented party's view being put more strongly or create or exacerbate power imbalances between the parties. So the party that's got money will be able to push their case hard and effectively, and the party that is already disadvantaged because they don't have the resources will be pushed into a position
where their case is not heard on equal terms. Mr Chairman, everybody in the House, you can tell from the national backbenchers with their heads down, know that this is wrong. They know that this is fundamentally inequitable. It's unfair, it's unjust. And this national government is doing it because they don't care about the people who can't afford representation. They don't care about the kids already in emotional turmoil because their family is broken up, where their case can't be put because there's a cut in the legal aid. And what this regulatory impact statement says, with no legal assistance for applying, some cases may not be considered by the court that should be. Cases that should be considered by the court, Minister, in your own regulatory impact statement won't be considered because there'll be nobody there to raise those cases and to point out the injustice and to ensure that a fair deal is done. That's not right. Some lawyers may not continue as legal aid providers, reducing the pool and the quality of those available for other legal aid work. We were worried, Minister, about the quality of legal aid work. There were reports on the quality of legal aid work, and by taking away the funding, the help that's available to people will be of an even lesser standard. Let's have a look at what your expert advisory committee said the risks of this would be. Most family court cases involve high stress to the parties, and for a wide variety of reasons, parties struggle to advocate for themselves in the legal process. The risk to vulnerable adults and children from a limited right to legal representation will be significant because in the absence of legal representation, and then it runs through about 8 different factors. So again, the expert group was telling you, your own department was telling you that this will result in injustice, and Minister, you don't care, do you? You don't care. You won't even take a call to justify your action. Well, I think you should do that, because this is about Robin Hood in reverse, taking money from the poor and giving it to the rich. David Bennett knows that. David Bennett knows how much tax cuts he got on his income, albeit as a insignificant backbencher. He got thousands. But the people that need the money are being denied it. It says here that there are hidden risks that would otherwise be a straightforward case that will not be identified. Cases will be more rather than less adversarial. Minister, you were telling the House earlier this evening that this is about helping families. The experts told you that by taking away legal representation, there will be a more rather than less adversarial position. It'll be more difficult, it says, to focus on the relevant factual and legal issues in cases where there is a risk for adults and children. More difficult to focus on the key things that should be before the court so that justice can be done, a fair settlement can be reached, and people can move on in their lives. And this bill stands in the way of that. It repeats the power imbalances between parties which permeate cases under this Act is more entrenched if the parties don't have legal representation. What is it about that, Minister, that you simply do not understand? That you increase the power imbalance in the cases where you're trying to find justice and justice will be denied. There will be a great direct and indirect cost to the public purse, they say, and also to society generally if there is a restriction on the right of the party to legal representation, and with it they grant to legal aid, and the legal aid, of course, is being taken away. There will be additional administrative resources required in court registries to deal with inquiries by parties by phone and in person. So you'll take away justice, but you'll actually add to the cost of the course. So many of the savings, the $12 million a year savings that you're lauding at the price to kids getting a decent settlement because their parents can sort out their differences, those costs will be there anyway. Family court judges will need to spend longer on each case to identify the issues, the risks and the optimum outcomes. This won't speed up the court process, this will slow down the court process, and that will cost more money. Spending more money but not getting justice. Why not just give them justice and allow the case to proceed in a swifter and more effective and efficient way? There will be more final hearings because parties will not have had the assistance of a lawyer
to assist in negotiation of a resolution. Everything about this bill is, Minister, bad, Minister, justified.
Mr. Chair, I have to say I don't think that effort of abuse from